This is 22337-8LT. This is Park Estates versus Alona McClendon. May I have your appearances, please?
Good morning, Your Honor. Sumchit Hart, peace on behalf of the plaintiff, Park Estates.
And Your Honor, this is Elizabeth Shepard for Alona McClendon requesting permission to practice under MCR 8.120.
Request granted.
Thank you, Your Honor.
We were last here on December 2nd, 2022, which time the parties indicated to the court that a settlement had been reached. Some of the terms of that settlement agreement were placed on the record. The court had the parties confirm they were waiving the right to today's jury trial. Attorneys for the defendant were to draft the order and circulate it for signing. Court left today's date on more as a placeholder to ensure that an order was filed. The court has not received anything. What is the status of this matter, Ms. Shepard?
Yes, Your Honor, we have been ready to settle this case from the defendant's side since last week. We sent opposing counsel our first COD on the 5th of December, sent a follow-up on the 8th after not hearing anything, sent another follow-up on the 13th after not hearing anything, which is when we finally heard back. And as you mentioned, many of these terms are already on the record, like about 95% of what we plan to be in that COD. And it was not until yesterday that plaintiff's counsel requested an NDA, as well as a no-fault clause, which we've already included the no-fault clause. But it was not until yesterday that those terms were brought up to us.
Ms. Hart?
Your Honor, if I may respond, that's correct. There was pretty much an agreement. It was placed on the record. However, also brought on the record that hadn't been discussed in a breakout room prior was an additional driveway provision. So we had to speak with our property manager about it. We could not get anyone to inspect the driveway in the interim of the last hearing. We did, however, come to a resolution on the driveway issue, which was hammered out with a provision in the COD that would include an inspection and repairs. However, the repairs would be open-ended as far as a date because of the weather. So we have resolved that issue. I was under the impression that an NDA had been discussed before then, and it would be sort of like a pocket judgment where we'd have a conditional dismissal placed on the record. However, the terms would be held back. However, co-counsel or opposing counsel indicated to me that agreement had not been reached. So that was a miscommunication on both of our parts, Your Honor. We have no problem entering into a COD with the defendants with the terms that we have agreed upon, the addendum of the driveway, which was not brought up last hearing.
The driveway was brought up.
And that's correct, Your Honor. It was brought up and I said I would look into it, but the exact details of when the repairs would be made and the escrow payment that they proposed in the COD had not been agreed upon. Since then, we have agreed upon release of escrow, the driveway inspection, and an anticipated date of repairs, which we haven't nailed down a date. It's just weather permitting.
Ms. Shepard?
Yes, Your Honor. That is correct that we have discussed and come to a conclusion on the driveway repair issue. However, we're still unclear on the NDA terms that were, again, not brought up by opposing counsel to us until yesterday. We
Ma'am, no. We don't interrupt. Ms. Shepard?
We've been willing and ready to settle this case, as I mentioned, since last hearing. We also still have not heard back on how Ms. McClendon should make these payments. As discussed on the record, she will be paying her pet rent, her regular rent for December. I'm sorry, her 360 for December, and the escrow for December would be released. But we still have not heard back about how she should make those payments from opposing counsel either. We're also a little unclear as the draft that we sent back has the COD with all terms specified on the record, with the exception of this driveway, as we just discussed. And we're a little confused because all the terms are already on the record, so an NDA would seem unnecessary as they're already public information.
Ms. Hart, before you respond, Ms. Shepherd, is it your position that you have a proposed order out to Ms. Hart's office and you have not received either a marked up copy back or an alternate proposed order back?
That is correct, Your Honor.
Okay, Ms. Hart, you have that, or your office has a proposed order?
We have the proposed order with the addition of the driveway that was just put out a couple days ago, Your Honor. And what I was saying earlier was if NDA had not been agreed upon before this, we have no objection to the entry of the order as it's been presented to us. I just have to sign it and get it back. I apologize, Your Honor. It was my understanding that one had already been agreed upon before my involvement in the case. So with the terms that we worked out that included the driveway specifically, we have no objection to what's being proposed.
You have no objection to the proposed order. Is that what you just said?
Yes, Your Honor.
So you'll sign it and send it back to Ms. Shepherd?
Yes, Your Honor.
So Ms. Shepherd will sign it and this court should have it when close of business today?
Yes.
Yes, Your Honor.
Yes, okay. Then let's do this. Mary Ann, what's our January civil trial day, civil date?
1 second.
Thank you, ma'am. I need to bring that 2023 short calendar out here.
January 6th.
January 6th, 2023 at 8:30 a.m. live in courtroom 1, which means in person here in the courthouse at 8:30 on January 6th. If this court has not received an order resolving this matter, I expect to see all parties here on that date at that time.
Judge, if I may, and I sincerely hope that we're not in a position where we'd have to appear on January 6th, but I am actually going to be out of town with my children on that date.
Professor Edmonds, you take away all my power and authority when I order people to appear and you
I'm
are out with
I'm
your
so
children.
sorry.
No.
I really appreciate.
Why are you apologizing for being somewhere with the kids? I just don't have my calendar. When are you back?
I'm back the afternoon, evening of the 6th, so I could appear anytime the next week.
I just don't have my calendar. Mary Ann, what's the next day? Oh, no, that would be Wednesday. That's somebody's criminal day. So the 8th?
Is a Sunday, the 9th,
Wait,
Monday?
no. Are we looking? Okay. Am I gonna have to go get a calendar? Because clearly
Here,
should not be.
I'm on my way.
No, oh, she said the wrong date. January 3rd is the day I'm looking for. The next civil day, Mary Ann, was January 3rd.
Okay.
So
Isn't it?
January 3rd is Tuesday.
It's a Tuesday. That's this court's criminal day I'm sorry, civil day is the first Tuesday of the month.
And let's say this, I will find someone from my office to appear on that day if it comes to it.
It's not gonna come to it though, because Ms. Hirsch has indicated that she is prepared to sign the order that she received from Ms. Shepherd. Ms. Shepherd, as the drafter of the order or participant in the drafting of the order, should be able to countersign what she's already sent over. Marianne, that is January 3rd is the civil date, right?
That's correct.
Thank you. It's more, again, to keep the attorneys moving forward. I'm not sure where this lack of communication comes from. It's not new. I'm always startled though when the attorneys don't talk between hearings. So January 3rd, 2023, 8:30 live in number 1 for entry of the order. If it means that we have to sit here and draft it on the record. But I expect that Ms. Hart will sign it, send it back, Ms. Shepherd will countersign it, and it will be in the Civil Department's incoming email. I said close of business today, that'd be fantastic because we're starting to get into the holiday season with our closures and short staffing. So Ms. Hart, do you need more than a day to sign what you have in your inbox?
No, Your Honor.
Same question to you, Ms. Shepherd. Is a day to get it signed and returned to the court realistic?
Yes, Your Honor, we can do that within the day.
As soon as we receive it, the civil staff will bring it up. I'll sign it. We'll get it back out to you. Otherwise, I'll see you here on January 3rd.
Thank you, Your Honor.
Anything
you,
else
Your
on
Honor.
behalf of the plaintiff?
Nothing additional for us, for Your Honor.
Thank you. Anything else on behalf of the defendant?
Nothing additional for us, Your Honor.
Thank you. That concludes this matter. Everyone have a happy holiday, safe travels to whoever is traveling home or on vacation.
Thank you, Your Honor.
too, Judge.
Thank you. You too, Your Honor.
Bye-bye. Always feel